Do not ask me. I'm asking you. Yes or no only. That's a very categorical
Same
question.
with Justice Baldos. I vote
not
for
for you
the
to
in favor of
judge,
the
Panero.
negative
You are
because it
under
is very
oath. This is
clearly
actually
provided
related to
under
your-
such a law that a 16-year-old can
the age
give
of
already
sexual
consent in sexual
I am
activity,
inclined to think that
the
it is
partner
the
must
age
not
of
be
16
3 years
is the
old.
age of sexual consent, and therefore I give it to the negative side.
Categorically stated there that the age of sexual consent is 16. The official statement of the Senate will bind me as a judge. So, there being no other sources to draw an answer from. No? That the age of consent is the
Ito po si
16.
Fiscal EJ at your service. Good day po sa lahat. Gusto ko lang po linawin ang pakahulugan ng Latin phrase na res ipsa loquitur. Habang nanonood kasi ako sa live stream ni Meloyap Reacts, napakinggan ko ang isang abogado na binabanggit niya ang res ipsa loquitur at ina-apply niya ito sa pag-describe niya sa isang dokumento in relation to a bigamy case. Pakinggan natin ang sinabi niya.
Doon na lang sa Senomar ni Rafi Tulfo. Dalawa yung kasal doon. At least dalawa yung kasal doon. Ano yung makikita mo doon na manifest? Bigamy, di ba? Ano ang ebidensya na ipapakita mo doon? Yung Senomar, di ba? Simpleng-simple lang. May tinatawag tayo sa batas na res ipsa loquitur. The thing speaks for itself. Even if the Senomar is your only evidence, malakas na yun.
In fairness, naintindihan ko naman ang punto niya about sa Senomar na ayon sa kanya, dalawang kasal daw ang makikita doon. And according to him, malakas na ebidensya na daw yun by itself to prove the crime of bigamy. Actually, sa tingin ko, ang gusto niya lang sabihin dito ay the document speaks for itself. Ang literal na translation kasi ng Latin phrase na res ipsa loquitur ay the thing speaks for itself. So siguro, dahil ang dokumento ay isang bagay din, he is of the opinion, I think, na ang res ipsa loquitur ay pwede mong i-apply sa laman ng isang dokumento. Actually, ang isang public document such as a Senomar under Section 23, Rule 132 of the Revised Rules on Evidence is already considered prima facie evidence of the facts stated therein. Ano ba ang ibig sabihin ng prima facie evidence? Prima facie evidence is such evidence that if not rebutted or contradicted, will be good and sufficient on its face to establish a fact. Kung hindi iko-contradict or ire-rebut ng kabila ang nakalagay sa isang public document gaya ng marriage certificate, birth certificate, Senomar and the like, magiging sufficient na ito to prove the facts as appearing in the said certificate. So ang tamang description pala na dapat ibigay sa isang public document gaya ng Senomar ay prima facie evidence, hindi res ipsa loquitur. Bakit hindi res ipsa loquitur? Ang res ipsa loquitur po kasi ay may specific na meaning at application. Let us start with its meaning in the dictionary. According to Merriam-Webster, res ipsa loquitur is a rule of evidence in tort law that permits an inference or presumption that a defendant was negligent in an accident injuring the plaintiff if the accident was of a kind that does not ordinarily occur in the absence of negligence. Sa Black's Law Dictionary naman, parehas lang ang meaning. Res ipsa loquitur means the thing speaks for itself. It is a rebuttable presumption that the defendant was negligent, which arises upon proof that the instrumentality causing the injury was in defendant's exclusive control, and that the accident was one which ordinarily does not happen in the absence of negligence. Our very own Supreme Court naman in a long line of cases, one of which is Interfield Laboratories Incorporated versus OEP Philippines, GR number 203697, has defined and or described res ipsa loquitur in this manner. While negligence is not ordinarily inferred or presumed, and while the mere happening of an accident or injury will not generally give rise to an inference or presumption that it was due to negligence on defendant's part, under the doctrine of res ipsa loquitur, the facts or circumstances accompanying an injury may be such as to raise a presumption of negligence on the part of the defendant. Furthermore, the Supreme Court in that decision stated, where it is shown that the thing or instrumentality which caused the injury was under the control or management of the defendant, and that the occurrence resulting in the injury was such as in the ordinary course of things would not happen if those who had its control used proper care, there is reasonable evidence, in the absence of explanation by the defendant, that the injury arose from or was caused by the defendant's want of care. In simple terms po, ang res ipsa loquitur ay isang doktrina ng batas na ina-apply sa mga insidente o kaso ng kapabayaan o negligence kung tawagin. For example, kahit na walang nakakita sa pangyayari o kahit na walang direktang ebidensya na nagsasabi kung sino ang may kasalanan sa nangyaring kapabayaan, the presumption is that the one who is guilty of negligence is the person having exclusive control of the thing or instrument that caused the injury. At base sa ordinaryong karanasan ng tao, hindi sana magkakaroon ng pinsala kung naging maingat lang ang taong may hawak ng instrumento o bagay na nagdulot ng nasabing pinsala. Ito po ang elements ng res ipsa loquitur as stated in the Supreme Court case of UCPB General Insurance versus Pascual Liner Incorporated, GR number 242328, promulgated on April 26, 2021. First element, the accident is of such character as to warrant an inference that it would not have happened except for defendant's negligence. Meaning to say in Tagalog, base sa kinalabasan ng aksidente, hindi sana magkakaroon ng pinsala kundi dahil sa kapabayaan ng defendant. Second element, the accident must have been caused by an agency or instrumentality within the exclusive management or control of the person accused of negligence. Ibig sabihin sa Tagalog, ang taong pinararatangan ng kapabayaan ay siyang may exclusive control sa instrumento o bagay na nagdulot ng pinsala. And third element, the accident must not have been due to any voluntary action or contribution on the part of the person injured. In Tagalog, dapat walang partisipasyon o hindi kagagawan mismo ng biktima ang nangyaring aksidente. Now, to better understand what res ipsa loquitur means, let us go through some examples. Example of the first element. Ito, may naiwan na surgical instrument sa loob ng katawan ng pasyente. Here, masyadong obvious o blatant ang negligence. Hindi maikakaila na ang doktor na nag-perform ng surgery ang siyang dapat managot sa pinsala na tinamo ng pasyente. Now, let's go to the example for the second element. Habang nag-aabang si Melin ng jeep pauwi sa jeepney stop, bigla na lang siyang binangga ng minamanehong jeep ni Randy. Again, obvious na si Randy ang may sala dahil siya ang mayroong exclusive control sa sasakyan na kanyang minamaneho. Example of the third element. Same example pa din, si Melly at si Randy. Makikita nyo sa example na yun na walang partisipasyon ang biktimang si Melly o hindi niya kagagawan ang nangyaring aksidente dahil nakatayo lamang siya sa lugar kung saan dapat siya mag-abang ng sasakyan, sa jeepney stop. So kahit na walang nakakita o walang gustong tumistigo kung gaano kabilis ang takbo ni Randy, under the doctrine of res ipsa loquitur, the presumption is that it was Randy's negligence that caused the injury. So ganyan lang po kasimple ang ibig sabihin ng res ipsa loquitur. Nag-a-apply lang po ito sa mga kaso ng kapabayaan o negligence. And definitely, hindi ito nag-a-apply sa isang dokumento to be used as evidence in a bigamy case. So yan lang po and maraming salamat and see you in my next video.